Great, thank you. Welcome, everyone. Good morning, good afternoon, depending on where you are. We're really happy to have you here with us today for the HOME-ARP question and answer session. Today, we'll have an opportunity to meet with HUD's Office of Affordable Housing Programs Leadership and subject matter experts, where you all, as participants, will have an opportunity to ask some questions related to HOME-ARP, particularly around substantial amendments, referral methods, qualifying populations, preferences, limitations, and methods of prioritization. We hope today that you'll put some questions in the chat box so that we can have our presenters answer those for you live. So if we can go over to the next slide, we have some great team members with us today. Again, I'm Jessica Lurs. I'll be one of the facilitators for today, joined by my colleague, Angela Nesbitt Rodriguez, and she and I will be asking questions of our panelists. So we'll have Elliot Tomes, Kimberly Johnson, Jeannie Sardone, and other OAHP subject matter experts in the field today here to answer questions and just provide some updates and insights to the HOME-ARP program. So without further ado, I'll send it over to Elliot to just lead us into the next part of our presentation.
Thank you, and good afternoon, everyone. I'm Elliot Toms. I am a Home HTF desk officer here at HUD in the Office of Affordable Housing Programs. I'm going to be presenting first, so let's get started. Next slide, please. So first, I'd like to go over some updates regarding HOME-ARP allocation plans and some data that we've compiled from plans that HUD has accepted so far. And first, we're very happy to report that nearly every PJ that received a HOME-ARP allocation ended up submitting an allocation plan. Only 5 PJs declined their allocation, so they did not submit a plan. HUD has accepted allocation plans for 615 PJs, with the remaining plans not accepted, still going through the resubmission and the review process. Our office collected data from PJs whose plans HUD has accepted and whose grants are fully contracted to determine the planned distribution of HOME-ARP funds by activity type. And the data showed that HOME-ARP PJs are planning to spend a majority, 53%, of the HOME-ARP funds that are available on affordable rental housing. So either acquisition, construction, or rehab of affordable rental housing. And that's followed by smaller dollar amounts going to non-congregate shelter, supportive services, and TBRA. Next slide, please. On this slide, we have a pie chart displaying the distribution of the total amount of HOME-ARP funding that PJs are planning to spend, separated based on activity type, with, again, the majority of the funds going to be spent on affordable rental housing. And also, based on the data reported in the accepted plans, we also anticipate that the HOME-ARP program will produce a total of 21,672 affordable housing units and support 23,805 units. And again, we gathered this data from allocation plans that have been accepted so far. Next slide, please. So before we get to the Q&A session, we've devoted some slides in this presentation to providing an overview of certain topics that many PJs have found challenging. In this slide deck, we're going to discuss HOME-ARP qualifying populations, or QPs, preferences, limitations, and methods of prioritization, referral methods, and substantial amendments. Next slide, please. So we're going to discuss QPs, qualifying populations. The HOME-ARP notice requires that HOME-ARP funds be used to benefit individuals and families belonging to 4 QPs. A PJ has to make sure that all 4 of the QPs at least have access to its HOME-ARP program. And these QPs include people who are homeless, people who are at risk of homelessness, people who are fleeing or attempting to flee domestic violence, dating violence, sexual violence, stalking, and human trafficking. Other populations for whom supportive services or assistance would prevent the family's homelessness or serve those with the greatest risk of housing instability. There's also an additional population, veterans and families that include a veteran family member that meet the criteria of one of the 4 QPs that I just mentioned. And it's important to use the HOME-ARP definitions for the QPs and not any criteria that's used for similar populations in other HUD programs, because the HOME-ARP QP definitions are unique from other programs, and we're going to elaborate on that further in the Q&A. Next slide, please. So preferences establish the order in which applicants are admitted to a HOME-ARP project or activity. PJs in HOME-ARP can establish reasonable preferences for certain QPs or a subpopulation within a QP. They can prioritize those applicants that qualify for a preference for assistance before other QP applicants that do not qualify for a preference. Preferences don't make anyone eligible who would not otherwise qualify for HOME-ARP assistance. So a preference can't make someone who's not a QP eligible for HOME-ARP. Preferences are different from limitations. And so limitations exclude certain QPs from eligibility for a project or an activity. And it's important to make sure that limitations as well as preferences comply with applicable fair housing and civil rights laws. And you should not impose a limitation on eligibility unless it's necessary to address a greater gap in housing or services in the PJ's geographic area. And the HOME-ARP project or activity cannot address the gap through the use of a preference. And finally, a method of prioritization is a process that determines how 2 or more eligible QP applicants qualifying for the same or different preferences are selected for HOME-ARP assistance. And it's important to know that a PJ cannot implement a method of prioritization if it does not also establish a preference. So without a preference, the PJ would have to admit applicants to activities or projects in chronological order. CEs, or coordinated entry systems, routinely implement methods of prioritization for the COC program, and that explains why when a PJ has no preferences, the use of a CE as a HOME-ARP referral method won't be very common. So now I'm going to turn it over to my colleague, Kim Johnson, who's going to discuss referral methods.
Thank you so much, Elliot, and hi, everybody. I will be taking everyone through the last slides that Elliot had just sort of introduced a couple of minutes ago. And then we'll launch straight into those questions that I know everyone wants answers to. So Elliot just spoke to us about preferences, limitations, and methods of prioritization. I'm going to be talking about methods of referral. So we have two methods that we're covering today. So there's some essential concepts about referral methods that I wanted to just talk about briefly before we talk about the three permissible HOME-ARP referral methods. Please note that preferences, limitations, and methods of prioritization affect the permissible referral methods for HOME-ARP projects and activities. Further, PJs must absolutely be aware of differences between HOME-ARP QP definitions and similar definitions used in other HUD programs when implementing methods of referral. PJs must collaborate with COCs serving its geographic area to appropriately expand the COC's coordinated entry system if a PJ elects to use that CE system as its referral method for its HOME-ARP projects and activities. Why is this the case? Well, because HOME-ARP requires it. Coordinated entry systems don't naturally include all QPs, and PJs must ensure that all QPs have access to its overall HOME-ARP program. Additionally, coordinated entry systems must be expanded because coordinated entry is also a method of prioritization, as Elliot just discussed. And coordinated entry implements preferences which may not align with the preferences a PJ has established in its allocation plan. HUD has established three methods of referral, which are permissible, and they are described on pages 10 through 12 of the HOME-ARP notice. These referral methods are expanded coordinated entry with other referral methods, and use of project activity waitlist. PJs can adopt different referral methods for each HOME-ARP project and activity, or use the same referral method for its entire HOME-ARP program. You have latitude. All right, so the very first referral method I'm going to talk about is project activity specific waiting lists. It can be used with or without preferences. It can also be used for implementing limitations that Elliot mentioned. Also, all eligible QP households that apply are placed on a wait list. Applicants are selected in chronological order of application, or they're selected consistent with any preference or method of prioritization established for that project or activity. Coordinated entry systems and other agencies serving QPs can refer clients to the waiting list. Please note, in the absence of preferences, the project-specific waitlist is the default referral method, and applicants are selected in chronological order. Next slide, please. Thank you. So the other two referral methods are expanded coordinated entry. With this model, PJs contract with a continuum of care or continuum of cares, if there's more than one, operating within the PJ's boundaries to accept applications through their coordinated entry systems and refer clients to HOME-ARP projects and activities, but only when the coordinated entry system has been expanded to accept all HOME-ARP QPs, and the coordinated entry system applies the preferences and prioritization established in the PJ's HOME-ARP allocation plan. The third permissible referral method is coordinated entry with other referral methods. PJs can use coordinated entry for certain QPs and supplement with referrals from other agencies or project-specific waiting lists to ensure access to the project activity for all QPs. In summary, there are 3 HOME-ARP designated referral methods. PJs must use any of these methods for its HOME-ARP projects and activities. We allow you to choose between the 3, but you have to use one. Next slide, please. Now we're going to turn to substantial amendments, just very briefly. Thank you. So again, as a reminder, a substantial amendment to the allocation plan is required when a PJ changes the method of distributing funds, or if it will carry out a new activity not previously described, changes the purpose, scope, location, or beneficiaries of any activity, and when the PJ elects to add new preferences not previously described in the plan. Please note that PJs must make the proposed substantial amendment, available to the public and provide the required 15-day public comment period as established in the HOME-ARP notice prior to submitting to HUD for its review. Now, there have been questions related to whether or not adding a specific project to an allocation plan triggers a substantial amendment. Well, if, let's say, a PJ has stated to HUD in its allocation plan that it was going to use HOME-ARP funds for rental housing activities, and then later identify several specific housing projects that it will fund, that does not mean the PJ has to come back to HUD with a substantial amendment, because it's already told us that it's going to use the funds for rental housing. But if PJ says they're going to use it for rental housing and chooses to change to non-congregate shelter, then that would trigger a substantial amendment. Now I would like to go, we're in the last several slides that I want to cover, and these are going to be about the different resources that we either have available or will soon be available. So next slide, please. Thank you. So we started back in October launching virtual clinics, and we had several on substantial amendments. And we're going to, oh, can you go back one slide, please? Now just forward one. Thank you. This is perfect. So we began doing the virtual clinics in October, focusing on substantial amendments. We're going to continue providing virtual clinics, an upcoming clinic on preferences. I think it's happening in January. We're also going to have one on qualifying populations and policies and procedures. In addition to these virtual clinics, we're also scheduling in the new year, starting in about March, in-person clinics, and they're going to be in all regions of the country, covering specific topics, including the HOME-ARP activities, which are rental housing, NCS, tenant-based rental assistance, supportive services, and important topics like policies and procedures. In addition to these clinics, we are also working to develop the written products and tools in support of those classes. Next slide, please. All right, so what's in the hopper, things to look forward to? Some HOME-ARP written guidance that will be wonderful to have. Non-congregate shelter due diligence considerations for acquiring properties. We're also going to have things in support of record keeping and documentation requirements for qualifying populations. I know we've been receiving lots of questions on these important topics. And also on tenant-based rental assistance sponsored checklists and capacity assessment for community development executives, so they can understand more about working with our nonprofit partners. Next slide, please. So at the conclusion of this training, I should say this Q&A session, these slides will be made available, and the slides on the next several pages have hyperlinks, which will take you to these wonderful and amazing resources that I hope you all read and that you share with your continuums of care, your subrecipients, owners, whoever is going to touch HOME-ARP. And I want to specifically call out for your attention the Introduction to HOME-ARP for COCs. We have several crosswalks for between PJs and COCs and about qualifying populations. And also at the bottom of this page, and it's only at the bottom because that's where it is, and maybe I'd put it at the top, would be HOME-ARP referral methods and coordinated entry resources. Please definitely take a look at this resource. Next page, please. Additional resources, many of these are more activity specific, especially to NCS, non-congregate shelter. Please look at these. And we also have, besides written guidance, we also have several webinars and other video resources that we would love for you to look at. And that the link is provided at the bottom of this slide. And these are all found on the HUD Exchange. Next slide, please. In addition, we have a lot of IDIS guidance for the HOME-ARP program that has been created, FAQs and tutorials. So please check these out, and there are going to be several new ones coming out very soon on HOME-ARP reports and HOME-ARP rental and rental operating projects. And we also have encouraged to, if you have IDIS HOME-ARP questions, to please use the links that are provided here, either to the HOME-ARP mailbox or Ask an IDIS question. Next slide, please. And so you may not know this, but this is the inaugural question and answer session that we are launching, and we're going to be doing this once a quarter. So please be on the lookout for the next one between January and March. In addition to holding these office hours, we want to remind you that we have the HOME-ARP mailbox. So please feel free to send your questions to that mailbox. Also, if you aren't already on the mailing list, we do encourage you to sign up and subscribe to the HOME-ARP mailing list. This is the best way to get announcements about new resources that have been put up on the HUD Exchange or upcoming training and question and answer sessions that will be scheduled. Additionally, we also have direct TA that is available, and please do feel free to submit your request, which will be reviewed through the TA portal. And you can certainly work with your local field office on that request, or you can send it directly to us in the TA portal. And that concludes my portion of the presentation, and I'm going to hand it back over so that we can open things up for questions. Thank you so much.
All right. Thank you so much, Kimberly and Elliot, for that great presentation. Lots of great information there. And thank you all for attending. We have with us today Jenny Sardone. She is the director of the Office of Affordable Housing Programs. So I want to welcome Jenny on. We have a few questions that we're going to ask Jenny first, and then we'll open it up to other HUD staff. So hi, Jenny. Thank you so much for being here.
Thank you so much for inviting me. And thank you to all the attendees from PJs, from nonprofits, and our field office staff for coming to join us today.
Absolutely. All right, Jenny, so first question. What are the differences between HOME-ARP QPs and eligible populations for ESG and COC programs?
That's a great question, and it's one that we can't really answer too frequently. So I'm going to do it again, even though I thought Elliot did a great job, because it's so important for both PJs and for program participants, nonprofits, and other agencies that are administering HOME-ARP funds to understand the very slight differences in the definitions that are used in HOME-ARP, and the sort of other definitions, particularly of homelessness and domestic violence, that are used in, for the consolidated plan, for COC, and for ESG, because Congress was very deliberate in making changes to those definitions. And so it's really important that when you're, and particularly when you're working with partners who administer COC projects or ESG, that you're speaking the same language and using the definitions and these terms in the same way. So essentially what Congress did in writing the HOME-ARP statute, and I was involved in a lot of those discussions, and I can tell you they were really deliberate in making changes to these definitions. So essentially, they took the definition of homelessness from the McKinney Act, which is also the comp plan definition, as I mentioned. And that definition has 4 paragraphs. They pulled the first 3 paragraphs of the McKinney Act definition of homeless into HOME-ARP, and then they deleted or omitted the 4th paragraph. And the 4th paragraph is basically the domestic violence portion of the homeless definition. And the reason, so they took that out. So when you're speaking of homeless, the homeless population, that QP in, for HOME-ARP, you're not referring to anyone who could qualify in the other sort of in the domestic violence definition that was established for HOME-ARP, which I'll talk about in a second. So it's really only that subset of the homeless definition. And so they pulled the at risk of homelessness definition directly from McKinney. So that one isn't any different. But then you get to the 3rd QP, which is attempting to flee domestic violence, dating violence, sexual assault, stalking, or human trafficking. So basically what Congress did is they wanted to eliminate they wanted to eliminate the requirement in the DV population that a victim or a survivor be on the verge of homelessness in order to qualify. So they created a new extended definition, which sort of was the DV, dating violence, sexual assault, stalking, human trafficking. So that's essentially the established definition that you see in HUD programs of domestic violence survivors. And then they added sort of the domestic violence, dating violence, sexual assault, and stalking definitions from the Violence Against Women Act. So that's the So that's the basis of that definition. And they also pulled in human trafficking, survivors of human trafficking, from the Trafficking Victims Protection Act of 2000. So that is a different definition. It is a much broader definition, and there is no component of this definition that talks about sort of people being homeless, on the verge of homelessness, not having support networks, so all those things that you're used to in the McKinney Act definition of homeless for DV, that's not part of our definition. And so those are really the main two differences, is the change that they made in the homeless definition and the way that they really expanded DV to a broader pool, including people who may have a lot more resources than the DV population that qualifies under the McKinney Act definition. So that's the main thing. It's a little confusing. You can certainly go back and look at the notice or some of the other things that we have on the HUD exchange about this, but you just need to be really deliberate when you're talking to HUD, when you're talking to your funded entities, to make sure that in the context of your HOME-ARP program, you're speaking of our qualifying populations. We're kind of past, fortunately, the allocation plan portion of this program, but I know that there were a lot of allocation plans that we ended up having to reject because the PJ was not using the definitions correctly. So definitely worth the little bit of time it would take to make sure you've nailed those down.
Thank you. Thank you for that distinction. It seems really important. So, all right.
Great. So we have another question, but we just want to remind participants, please use the Q&A box for any additional questions that you might have. We'll be getting to those as we go through the rest of our session today. Next question. Can you discuss the HOME-ARP requirement that a PJ's HOME-ARP program provide access to all 4 QPs? Could separate activities be set up for each QP so that the overall portfolio serve all 4 QPs?
Right. Another great question, and another sort of question that's sort of causes a little bit of confusion out there. So I'm happy for the opportunity to address it, even though I think Kim did a great job of addressing it as well. So this really gets back once again to congressional intent. The way that Congress wrote the HOME-ARP statute, which is a wholly different statute than the home statute, they established these 4 QPs, but they made it clear in the drafting that the intention was that the funds would serve all 4 QPs. And so what that really means in practice is that you can establish preferences in your program. You can even potentially establish limitations if necessary in your program, but there has to be some part of your HOME-ARP program that is actually accessible to any one of the 4 QPs. So what do I mean by that? Congress clearly intended that all 4 QPs be served. But they did not prohibit preferences. So for instance, you may use your entire HOME-ARP allocation, for instance, to run a supportive services program. You can establish a preference, let's say for the homeless QP in that, in that program, but you're not, you're allowing all the other 3 QPs to access the program. They can put their name on the list. Now, your homeless population in your jurisdiction may be of a sort of a sufficient size that by sort of prioritizing and giving this preference to the homeless, the non-homeless QPs, the folks from the other 3 QPs, never actually get to the top of that waiting list and receive the supportive services. That's unfortunate. but it's actually permissible because you've allowed access to the program. It's just that the preference resulted in none of the other 3 QPs being served because of the size of the need of that QP. Where I think we've had some PJs that have run into issues is wanting to fund 1 or 2 activities. I can think of one situation where it was 2 rental projects and another where it was a single rental project, and limit the project or projects to a single QP. So if you, let's say you're a smaller PJ and your HOME-ARP allocation is just sufficient to allow you to fund development of 2 rental projects. And you want to limit both of the occupancy of both of those projects to people from the homeless QP. That's not permissible because you are not providing access to the other QPs to your program, because those 2 rental projects are your entire program. However, if you wanted to do something like have a project with one project with a limitation and 1 project open to any of the 4 QPs, that would actually be okay as long as the limitation itself didn't create fair housing or civil rights problems, which I guess we'll talk about in a few minutes, because there's access to the program overall. So it's possible to have preferences or limitations and still in a program and still be providing access to all of the QPs. But if you're doing a single activity or a single project and you want to place a limitation on the project, you are basically violating the law because you're not providing access to the program to all the QPs. So this is why, that we say you really should not use limitations in your program unless it's absolutely necessary, in order to serve that population. And of course, you're offering some other HOME-ARP funded activities to serve everyone else.
Perfect. Thank you.
Thank you so much. And that does kind of lead us into the next question. Can you discuss some of the fair housing concerns that a PJ should consider when developing and implementing the HOME-ARP program? And in particular, are there any concerns that may not arise in the ESG or COC programs that they might run into in the HOME-ARP program?
Right. So yeah, there are a few potential bumps in the road here. So in HOME-ARP, there's we definitely have Section 504 accessibility requirements applying, and all of the other fair housing and civil rights requirements that apply essentially to, in the case of rental housing, to housing. Shelter is also a little bit different than what you would see in COC or ESG. So for instance, in ESG, there are a lot of shelters that are funded to operate that are congregate shelters. And in some of those shelters, because of the configuration of the shelter, with respect to, sanitary facilities, showers, bathrooms, that kind of thing, where it's possible to do a single sex shelter because it is congregate. However, in HOME-ARP, the eligible activity is non-congregate shelter. So by definition, the units are enclosed, they have in-unit sanitary facilities. And so a HOME-ARP funded shelter cannot be single sex because by definition, they don't meet the standards for an exception for the exception that you might be able to get in an ESG funded shelter. that would permit it to be single sex. So that would be one, that would be one example. I think another example we've seen a few times is shelters that are, that are only for adult, ESG funded shelters. I want to be clear, that are only for adult men, or only family shelters. I can't, I'm not a fair housing expert, so I can't, necessarily address exactly how those are eligible in those programs. But once again, in HOME-ARP, because these are non-congregate shelters with enclosed units, you can't have an adults-only shelter or a family-only shelter, because it doesn't meet any kind of an exception test, because the units are enclosed. So, single sex shelters, or shelters that differentiate, or one could say discriminate based upon a familial status. Either you have children or you don't have children. Those would not be permissible in HOME-ARP. And so, I think the advice that I would give everyone is sort of, if you have any questions of this type, you can send them into the HOME-ARP mailbox, or go directly to the FHEO division in your local HUD field office and have them sort of help you figure out whether the activity that you want to fund is going to violate any kind of a fair housing or civil rights requirement, and how you might be able to restructure an activity to ensure that you're not running afoul of the law.
Thank you so much.
And a related question, thinking about limitations, can you provide some examples of permissible limitations and examples of proposed limitations that would violate the fair housing and equal opportunity laws?
Sure. So a good example is a non-congregate shelter for people or sort of families who are in the HOME-ARP DV qualifying population. That is a permissible limitation to limit to DV based upon the protections, the legal protections for that population. You can actually limit in that way. However, if that same shelter were a single sex shelter for NCS for the DV population, that would be an impermissible limitation, once again, because non-congregate units, these enclosed units, don't qualify for the exemption from the Fair Housing Act sort of prohibition against single sex. So that would be one example. Another would be a shelter, or even a homeless, even a rental housing project. You could have a preference or even a limitation, as long as you were serving other QPs elsewhere. For instance, people in the homeless QP with disabilities. That would be a permissible preference or a permissible limitation. However, if the preference or the limitation were for homeless people under our QP definition with a specific disability, that would actually violate Section 504 of the Rehabilitation Act. And so, for instance, you couldn't do a shelter or a rental housing project that was only, for instance, for homeless people with substance abuse issues, because that would be prohibited by Section 504. But the thing that I do want to stress is that there are, in the Section 504 regulations, there is an exception ability. And sort of the regulation kind of walks through what would qualify a housing project or a facility for that exception. to permit a disability-specific project. So, for instance, a project, a shelter or a rental housing project that served homeless people with chronic mental illness, that might be an example of a project could qualify for that exception. But it is really important that you don't assume that your project can qualify for the exception, but that you go and talk to FHEO or sort of contact us through the HOME-ARP mailbox and have us connect you with fair housing people who can make sure that you are not, once again, violating any of the civil rights or non-discrimination laws.
Perfect. Thank you so much. And of course, keeping everything in file and documenting all of that is always important, right?
Always.
Yeah. All right. So thank you so much. We are seeing a lot of great questions coming in. Please remember to put your questions into the Q&A box. And recently, WebEx underwent a little update. And so I think the Q&A box might look a little different than you're used to. So down at the bottom right-hand corner of your screen, you should see a green icon with an S in it. And that is now the Q&A box. And so if you open that, click that icon, you should be able to insert your questions there. But please keep the questions coming. There's some really great ones coming in, and we're looking forward to getting to them. So now I'm going to open it up, and this question is for anyone at with OAHP. Is the method of prioritization required when a PJ intends to implement multiple preferences?
Hi, I can answer that. This is Kim. And yes, regardless of whether you have one preference or 10 preferences, which would be a little crazy, but yes, you do still use the method of prioritization. There's a requirement. If you don't, or if you're not going to have any preferences, then you don't need to think about a method of prioritization. But the second you have one preference, you're automatic.
Perfect. Thank you so much.
Great. We've gotten a couple of questions related to some LIHTC things, but just want to put this one out there. If a HOME-ARP project will also be 100% LIHTC funded, is the PJ required to establish a preference or limitation based on the income restriction?
I can answer this one. Hi, this is Caitlin Renner. So we did speak to council about this particular question a while back, but it still continues to come up. But what they advised was that restrictions imposed on HOME-ARP projects due to statutory requirements of other programs, like an income restriction for the low-income housing tax credit program, is not considered a limitation because it does not limit access to any of the 4 QPs. It would be more of layering of restrictions. There needs to be a restriction on the property to ensure that units are occupied by QP qualified HOME-ARP QPs, and then restrictions as well, ensuring income eligibility for the LIHTC program. So if that income restriction is not sort of a program design of the HOME-ARP or decision of the PJ, but rather a statutory requirement of another program, it's not considered a limitation on the project and is not required to be established in the PJ's plan ahead of time. If there's another program that is, it contains a statutory requirement that would actually limit to less than all 4 QPs, that is something that needs to be described in the plan.
Wonderful. If a PJ uses expanded coordinated entry as its referral method, does the marketing associated with the coordinated entry meet the HOME-ARP affirmative marketing requirements? So if a PJ uses the expanded coordinated entry as its referral method, does the marketing that's associated with the coordinated entry meet the affirmative HOME-ARP affirmative marketing requirements? Or maybe does it need to meet?
I'll go ahead and jump in on this one again. So no, the the existing marketing that might be done by the CE system would not meet the affirmative marketing requirements for HOME-ARP for a couple of different reasons. The first being that, as Jenny described, the qualifying populations for HOME-ARP are not the same definitions that the CE is currently using for other homeless assistance programs. So that's one issue, is that it's not, marketing broadly. Another issue is that the marketing that's currently being done is to reach specific populations, but the HOME-ARP affirmative marketing requirements mean that PJs have to ensure their marketing or their subrecipients are marketing, or the projects are marketing to those who are least likely to apply for the program. And so there are some groups of individuals and families that meet QP definitions that may not necessarily access services or housing or shelter through COC programs, may not consider themselves to be homeless or at risk of homelessness, or just aren't addressed at all. And so there's a lack of awareness there. So I think some PJs sometimes think also of affirmative marketing as like a civil rights requirement, but it goes beyond that. It's not just about language barriers, or reaching out to minority populations, although that's important. It's about thinking about, for the particular program or project that's being assisted with the HOME-ARP funds, what are the populations that might not currently be kind of connected in with those resources. So just as an example, I think a lot of COCs, they already have established systems to reach out to do street outreach, right, with certain service providers that may be connected with the CE. So the literally homeless, probably are likely to get connected if they're interested with the types of services and housing, shelter that's being assisted through HOME-ARP. But the people that are victims of human trafficking may not consider themselves to be homeless, even though they might be. They may not already be connected through those traditional channels, just as an example. And I think also, just because there is a sort of a new definition as well regarding other populations that don't traditionally meet the at-risk population, there are folks that are in need that may not, be calling the traditional helplines and be connected in. So it's important to think about those least likely to apply to meet those affirmative marketing requirements.
Thank
Great.
you.
And another related to referral methods question: is it acceptable to establish different referral methods for one HOME-ARP activity or program? And Kimberly, I think you touched on this in your part of the presentation, but I don't know if you want to answer that one.
Yeah, certainly. So I'm so sorry. Can you just repeat the question?
Sure.
I just want to make sure I got it
Absolutely.
completely.
Is it acceptable to establish different referral methods for one HOME-ARP activity or program?
Well, so if we're talking about a program, right, that's the overall program. So then the answer is yes, you could have different referral methods for the various activities or projects that are part of the HOME-ARP, the PJ's HOME-ARP program. The different referral methods for one particular activity, I guess that's possible, and I would sort of ponder this like maybe over the course of, say that this is an activity that goes on for several years, and the provider is realizing that whatever the referral method is that they're using isn't working, then certainly shifting from one type of referral method to another. I'm not sure if a PJ, how the PJ would oversee sort of an activity where there are multiple referral methods for that activity. Might be good to have more information from the PJ to really dig deep and understand more clearly what the particulars are, why more than one referral method might be necessary. I mean, because I think the referral method that we have where it's coordinated entry with other referral methods or other, ways to refer in would be maybe the one that the PJ should think about for that activity.
And I would just add that, just to clarify, I agree with Kim, that there's no requirement that the referral method be established across, like Kim said, the whole of the PJ's HOME-ARP program, or activity by activity in terms of, like, for example, the HOME-ARP rental activity. It's not required that all HOME-ARP rental projects use the same referral method, right? The referral method is going to be established in the PJ's policies and procedures and the written agreement. So it is totally possible that a PJ may fund different developers for different types of rental projects, and there may be some reason to use different referral methods. That definitely complicates administration of the program, but it's permissible. And the same would go, for example, for a supportive services activities. If the PJ was funding different subrecipients to run different supportive services programs, there may be, and maybe one of them is a targeted program that has preferences and the other one is not, there may be a reason to use different referral methods, and that is permissible.
Perfect, thank you.
All right. So if a PJ did not establish preferences or limitations, but then received an application for funding from a nonprofit that only serves a certain QP subpopulation, must the PJ then amend its plan in order to serve that subpopulation only?
Hi there. The answer is yes. The PJ would have to do that, would have to go through the substantial amendment process.
And I think, we would also just remind PJs as they're developing their RFPs and other processes for awarding funds to think about, are they designing those RFPs in a way that sort of targets the funding to meet the goals that were established in the plan. So, we do expect that PJs will get more specificity through the RFP process and determine that preferences are necessary and make, substantial amendments to plans, and all of that is fine. But we would encourage PJs to direct the development of HOME-ARP projects and how the assistance is provided based on the plan that you laid out. And so hopefully the responses to RFPs or other types of solicitations actually meet the needs that were identified, if PJs are choosing to fund those projects and activities.
Makes sense. Those needs that were identified during the public participation, public input process during allocation planning. So kind of a similar question. Is it best to issue an RFP by eligible activity or to issue an RFP by qualifying populations?
So I'll take that. And I would actually highly encourage that the RFP should identify both the eligible category and the, QPs that would benefit from that activity. And especially to clearly identify if, the expectation that there would be preferences as well. Because we certainly would want whoever the applicants are to submit responsive applications to that RFP so that the PJ can implement its allocation plan as, accepted by HUD, and, how it informed the community it would use the funds. So, as Caitlin is saying, the more clear it is in the RFP, the more hopefully likely the PJ will get responsive applicants.
Thank you so much.
We've gotten a couple of related questions to this, and it's about substantial amendments. And this one is about a very particular example, but I think we've seen a few more in the chat, somewhat related. But If a PJ's approved plan establishes a preference for QP1, but a developer proposes a permanent supportive housing project for a subpopulation of QP1, is the PJ required to amend its allocation plan, or is the established preference sufficient?
Hi, I'll jump in, and certainly people can follow up after me to embellish any additional information. But I would say that yes, the PJ must definitely go through the substantial amendment process because while we have the PJ's informed what QP would be preferenced, the public and certainly HUD has no idea of what subpopulations might be included in that QP. The QP homeless is just homeless. There are a lot of subpopulations within that, and we can't presume to know exactly what subpopulations the PJ was thinking when they put their allocation plan out for public comment and submitted to HUD. So definitely they would need to go back into HUD with their substantial amendment.
All right. Can a county that received HOME-ARP funding fund a project in a city that's located within that county?
Sure. So that would be considered a jointly, would only be permissible as a jointly funded project or activity. So in order for a PJ to fund a project in another PJ, a contiguous PJ, both PJs must contribute funds to the project. It must be jointly funded, and the PJ should be sure that the project it's funding actually serves the needs of its population and not just population of its neighboring PJ, or in this case, perhaps a city within a county PJ.
Perfect.
And I know I've seen a couple of these questions in the chat. May PJs request a waiver? This is for non-congregate shelters in particular. May PJs request a waiver for the in-unit sanitary facilities requirement for non-congregate shelter to permit shared sanitary facilities?
This is Ginny. I'll take that one. So this is a question we've gotten a couple of times now. And so I want to start by saying that this is not a statutory requirement. Therefore, it is possible to waive it. However, going back to congressional intent, the intent of Congress when it added NCS, non-congregate shelter, which it did at kind of a very late age of putting this statute together, was to ensure that it wanted to offer jurisdictions, states and local governments, sort of the ability to upgrade their shelter stock from congregate to non-congregate. And so, we have, as part of this, part of this idea of what non-congregate shelter is, HUD really believes that that includes in-unit sanitary facilities. So a PJ can always request a waiver, but HUD can only grant a waiver based upon a finding of good cause. And so from our perspective, given the congressional intent of HOME-ARP, cost is not good cause, or convenience is not good cause. The only thing that would really be good cause, I think, is that there would be some benefit, some benefit to a congregate shelter that could not, or to sort of not having sanitary facilities in the units, that would, that would benefit the occupants in some way. And so I guess what I'm trying to say is you can request a waiver. We think it will be difficult for a PJ to establish good cause based upon the purpose of HOME-ARP. And so no one should count on a waiver.
All right. Next question. Does HUD have to approve a substantial amendment before a PJ can proceed with implementing the plan? And similar question, is HUD required to review and either approve or disapprove a substantial amendment within a certain period of time?
I can start answering this question. So does HUD have to approve a substantial amendment before a PJ can proceed with implementing the plan? Yes. And I know that this is a little bit different from other kinds of substantial amendments that PJs have done in the past related to, say, CDBG and home, where the substantial amendment is not something that HUD necessarily has to approve in advance. You're informing us that about certain kinds of changes and certain documents are submitted to HUD at that time so that we're informed. However, with the HOME-ARP, we do require that before any changes are made to an accepted allocation plan, that HUD does the review, and it does have to be done within, I believe, is it 30 days? I'm not quite sure about that.
So hi, this is Shannon. The timeline on that is going to be similar for the regular the submission of the allocation plans, I believe. So it'd be the initial review within 45 days, and then if it's disapproved, then the resubmission, the second review of the allocation plan substantial amendment would be a 30-day review on any resubmissions after that.
Thank you, Shannon.
Mm-hmm.
Thank you both.
Okay, so we had a couple of questions about rental assistant or HOME-ARP rental projects. So can you speak about what a PJ should consider if combining HOME-ARP and home or LIHTC in the same unit or same project? That's probably a big question.
So I think Ginny did want to speak to this one, so please feel free to jump in, Ginny. But one thing, we get this question all of the time, and I think rather than telling you what to consider if you combine home and HOME-ARP, what we've advised is that you consider not combining home and HOME-ARP in the same units, because we issued a number of waivers and statutory suspensions for HOME-ARP in order to provide some flexibility. And so if you combine home and HOME-ARP, particularly in the same unit, but even in the project, you are losing those flexibilities. And in addition, you're gaining new requirements that are different, right? Because the QP definitions are not the same eligible populations as the low-income population for home. So we really advise against just immediately filling gaps in your home projects with HOME-ARP, and really thinking instead, consider what kind of complexity that adds to the oversight of that project, both upfront and for underwriting purposes, and then ongoing during the period of affordability, because it may make it a lot more complicated. May be a little bit easier with the Housing Trust Fund program, which often does seem to be used to fund projects with deeper subsidy, has lower income levels, and often folks with special needs as well.
All right. So is there any guidance on using HOME-ARP funds for operating cost assistance and reserve for rental housing?
I do think we have our rental subject matter expert on the phone, so I hope you will join in. I would start by saying we're actively working on tools for this purpose. So right now there's no written guidance, but we're working on underwriting tool and specific technical assistance products on operating cost assistance reserve and thinking through policy questions that you may have as when you're trying to set up a reserve or fund operating cost assistance.
Right.
Okay, we have a cross-cutting question related to Section 3. So this particular question says that Section 3's FAQ states the project is the site with any buildings and improvements on the site that are under common ownership and management. Does that mean the original development, even through HOME-ARP, is part of a phase 2 renovation? Is that part of the rental project?
So the Section 3 definition of project is the same as the home definition of project, and so therefore the HOME-ARP definition of project. And the way that so to repeat with that, it's building or buildings on a site or sites under common ownership, management, and financing. And the way that what we've always advised is that multiple phases are not part of the same project because they generally are phased because they have separate budgets and they're separate undertakings. So they may have the same owner, but they probably not under common financing. We find with home in particular, home may fund just one phase of a much larger project, like a large multi-phased tax credit project or redevelopment of a large block or neighborhood. And so if home is only going into one phase, then that is the home project. And so that applies for HOME-ARP as well. If HOME-ARP, or home, we're not in another phase, that's not common financing. So that's not considered part of the same project. That is the way that the home and HOME-ARP programs define project. Don't, use that definition for other programs because project could mean something different under other HUD funding sources. So I hope that answers the question. I didn't totally understand the question, but I hope that gives folks a better understanding of the definition of project and that how it applies to Section 3 as well.
Does the recent HUD reduction or increase of HOME-ARP fundings for PJs trigger a substantial amendment?
So HOME-ARP is a one-time appropriation. Therefore, there has been there's no change in funding. So maybe I'm misunderstanding the question. I will say that, and maybe we touched on this earlier, if a PJ is adding funds to one activity from another activity, doesn't necessarily trigger a substantial amendment. Really, the substantial amendment is only required if required by your citizen participation plan due to changes over a certain size in activity funding levels. If anyone else on the team has any sense of what, any more insight into this particular question, please chime in.
Yeah, I'm so sorry. Oh, yeah, sorry, go ahead, Shannon.
I'm wondering if this is about the formula for the allocation, if PJs are wondering if they need to,
Yeah,
Yes, and I don't know the answer, but I think that's what it's about.
Yeah. So this is probably not knowledge for everyone on the line, but there was notification sent out to 33 states that they received too much HOME-ARP funds. And as a result of that, their blocks balance was reduced by the amount of the estimated overage. So the amount over allocated to these 33 states has not been finalized yet. We have a contractor working to finalize those amounts. So I think it would be premature to do any kind of substantial amendment or any change. We haven't amended grant agreements. We haven't even reached a final number on those amounts that were over allocated. So hopefully that answers the question.
All right. I'm going to move to a supportive services question. So if any one of our supportive services SMEs or anyone wants to answer this one. So for supportive services short-term and medium-term rental assistance, the notice states that the PJ must enter into an agreement with the landlord. The question is, can recipients administering the program sign the lease agreements with the landlords on behalf of the PJ?
Hi, Jessica. This is Diane. I'll take that question.
Great.
So just as in the home program, a subrecipient is a public agency or a nonprofit organization that's selected by the PJ to administer all or some of the PJ's, in this case, HOME-ARP program. So if the PJ has a subrecipient that will administer the financial assistance for rent component of the supportive services activity, the subrecipient could enter into the lease agreement on behalf of the PJ. The duties and the responsibilities of the subrecipient, those must be outlined in the written agreement between the PJ and the subrecipient.
Great. Thank you so much. So another supportive service question. Can HOME-ARP supportive services be limited to a HOME-ARP rental or non-congregate shelter project? So can you provide HOME-ARP supportive services just for that particular project where the people who are served have to be living in that rental or that non-congregate shelter project? And then related, is the PJ required to establish a limitation for that kind of program design if it's allowed?
Hi, this is Shannon, and I'll address that question. So if supportive services are going to be funded in conjunction with HOME-ARP rental or HOME-ARP NCS project, a preference or limitation does not need to be established to only provide supportive services to individuals who are residing in the rental units or who are staying in the NCS units, because that's a programming decision, and it would be coupling the HOME-ARP supportive services with the HOME-ARP project, and that would just be a program design decision. Similarly to that, however, if I've seen some plans come in where, and some questions come in about whether or not HOME-ARP supportive services can be limited to people residing in rental units or non-congregate shelter units that are not funded with HOME-ARP dollars. So that would mean that there's already existing rental units and they just want to limit and only support people with HOME-ARP supportive services, supporting people who are living in one particular facility. And that is not something that can be permitted as a limitation or a preference. It needs to be broader to all of the QPs or subpopulations. Did that answer the question?
Yeah, really great. Thank you.
Okay, we have an IDIS question. So whoever's able to answer this one, can a PJ set up a HOME-ARP activity in IDIS under any Home 2021 project, even if it is not related?
So, hi, this is Peter again. So, the answer to this question is technically yes, they could. We do have a fact sheet out there on HUD Exchange and HUD.gov. It's called Creating HOME-ARP Projects and Activities in IDIS. It's a fact sheet. There are a couple of different options. The first option, the PJ could create one new HOME-ARP project and associate all the HOME-ARP activities under the single HOME-ARP project. That option requires an amendment to the 2021 annual action plan. The second option would be to create multiple HOME-ARP projects. This is based on however the PJ typically creates their annual action plan projects, and then associating specific HOME-ARP activities with each HOME-ARP project. And that option would also require an amendment to the 2021 annual action plan. The third option would be to associate a HOME-ARP activity or HOME-ARP activities with existing 2021 annual action plan projects, and that would not require an amendment to the 2021 annual action plan. So HUD has come out and said that any of those three options would be acceptable.
Great, thank you so much. All right, going to go back up to rental housing a little bit. Can capacity building and operating assistance be offered in connection with acquisition and development? And if so, would a development consultant be an eligible cost under capacity building?
I'm sorry, this is Shannon, and I can support the capacity building and operating assistance questions. Would you mind just repeating that again, please? Sorry.
Absolutely. Can capacity building and operating assistance be offered in connection with acquisition and development? And if so, would a development consultant be an eligible cost under that capacity building activity?
And then this is might require a question come into HOME-ARP, or if anyone else wants to jump in. But the capacity building and operating assistance for nonprofits is what that is established for specifically. So if it's a nonprofit developer and there needs to be a need for them to have increased capacity or operating assistance, and it needs to be relevant to them being able to carry out a HOME-ARP project or activity in the future. That's the intent of it. So if there's if there's a need to have that capacity building or operating assistance in order to increase their capability to deliver a HOME-ARP project or activity, that would probably suffice under that. They could choose to use that for operating assistance or capacity building how they would want to. The trick with that, though, is that the operating assistance needs to not be tied to any particular project or activity. And capacity building would be, increasing the agency's ability, so that might be more applicable. I don't think I answered that very well, but if there's additional questions, or if someone else wants to jump in, it might be a good question to submit if someone has additional questions in that arena.
I thought, the way you answered it made sense. That's how I would answer as well. And I guess I would just say that if it's the question referenced a consultant. If the nonprofit needs to hire a consultant to undertake the rental project specifically, that may be paid through soft costs of the project rather than the capacity building. So I would take a closer look at. I think that there's certainly funds that can be used because nonprofits, if you're doing a development project, there can be a developer fee and there can be income that's used to, soft costs of the project used to pay for whether it's, plans or underwriting or construction management. I mean, there's certainly costs that are eligible. I just think it's a matter of which type of cost, right? And so I don't, because we're talking about a specific project, I tend to agree with Shannon that it's probably not nonprofit operating and capacity building.
So I just wanted to add too that this is one of those very specific questions And so it may be helpful for whoever's asking this to just send us something through the mailbox so we can work with you through your field office and provide you. Because I mean, I'm not entirely clear, what this person means by a development consultant. So that's what I would add to that. Please send us that question through the mailbox so we can assist you further.
Thank you. All right, we have about 4 minutes left, and I have one final question for HUD. Is there any advice that you would give a PJ during this time of HOME-ARP implementation and planning?
I don't know if Jenny is there because I thought she was going to take this question, but I can start, and then other OHP folks, please feel free to jump in. HOME-ARP is in the home frame, but it is absolutely a very sort of different program, right? Because it targets all these qualifying populations, and it's not income using income eligibility the way that we do with normal home. So, PJs are, and I think I saw this question in the chat as well. Can I use my regular home underwriting to underwrite HOME-ARP? The question is no, because it's not the same folks, right? You're probably dealing with folks in a rental project that have no income, and you want that rental project to be sustainable. So using the same underwriting criteria that you have for home wouldn't work. And so I think that for me, my advice to PJs across the country is that, first of all, understand that these are two very different programs, right? It is in the home frame, and you need a good understanding of home in order to be able to do HOME-ARP. Please take the trainings that we have and the resources that we have on the HUD Exchange. And if you have a challenging question, please reach out to us. We're here to assist you. We're here to support you. We're really grateful for all that you're doing for the folks that are going to be benefiting from these resources. But we do recognize that this is going to require a lot of assistance. We're working on technical assistance products to assist, like the underwriting tools and things like that. It's taken us a bit of time. We'll get there. And obviously, please be patient with us. But please reach out to us because we can provide some of that technical assistance. We do have a lot of direct TA money. So please reach out to us. And if this is something that we can assist with by just, getting on a phone call and walking you through, we have staff that can do that. If it's something that we need to assign a provider to, we can do that. But talk to us and we can try to help you.
Henrietta, this is Ginny. I'm sorry, I've had a sort of a temporarily brain I don't know, senior moment or something, and I couldn't get myself unmuted quickly enough.
No worries.
So, but I think you did such a good job answering the question that I'm not sure that there's a whole lot more that I would say. However, I do think, I want to reiterate, please reach out to us if you have any questions. We want to make sure that you're, that you're able to complete really effective and compliant projects with your HOME-ARP funds. We understand, it is a challenge. We issued 68 pages of waivers of home statute and regulations in order to create HOME-ARP, kind of out of, out of what was left of our statute after we were done. And so even though we think this is a really unique opportunity to get some capital funding and sort of supplemental funding for supportive services, it is a different program. It is not like COC or ESG, and it's not, it's very different than home at this point. So, we've been able to hire, staff specifically to help PJs with their to develop and to operate their HOME-ARP programs. Henrietta and her staff are doing an amazing job and working on a lot of different templates and tools and trainings and products for you all. And, so we do ask that you be patient, but, while we get all of that out. but we really do mean it when we say reach out to us, because we're here to help you. So that's so really just reiterating Henrietta's message to you all. Sorry about not getting off of mute quickly enough.
Thank you.
Well, we just want to thank everyone that joined us today, all of our participants. Thank you for asking such great questions and continuing to ask those. And as Henrietta and Jeannie said, continue to submit those. There are a group of people ready to kind of try to answer those for you, and products to be coming in the future. Thank you to all of our OAHP staff for your great answers to all of these questions. It can be really hard to answer things on the fly like this. So we really appreciate you, and thank you to our WebEx team and my co-facilitator here today. We hope you enjoyed it, and we'll see you at the next one. Take care.
Bye, everyone.
Thank you. Bye.